We appreciate the time you choose to spend with us here on the 208, and we appreciate the time of day you allow us into your homes, which is why we feel the need to tell you we're about to talk about something that might make you uncomfortable. But it's something we have talked about before on the 208, when we thought it would be fun to look into Idaho's love laws on Valentine's Day. We did dip into the sex crime section of Idaho law just a little bit. And yes, it is still illegal for people to have sexual relations out of wedlock. Title 186603, it reads, any unmarried person who shall have such relations with an unmarried person of the opposite sex shall be deemed guilty of fornication. It's on the books. Those found guilty could be punished with a fine of up to $300 or up to 6 months in jail. That law has been around since the 1920s, and these days it's only been used, and rarely that is, in underage prosecutions. You may have caught that opposite sex part of that law, but before you think, well, same sex, fair game, not so fast. Idaho still has an infamous crimes against nature statute, and that could cost you 5 years in prison. Okay, we're back here live. So that statute is known as Title 186605, and it says every person who is guilty of the infamous crime against nature committed with mankind or with any animal is punishable by imprisonment not less than 5 years. So what is the infamous crime against nature according to Idaho law? Well, it's sodomy or oral copulation. Yeah, that's still illegal in Idaho. In fact, the Idaho State Supreme Court upheld a conviction of that crime just 3 weeks ago. And according to Idaho code, anyone found guilty of a crime against nature is also required to register as a sex offender. Well, for the first time since 2003, someone is challenging that law. This week, John Doe filed a lawsuit in Boise's federal district court because the U.S. Supreme Court back in 2003 already declared such laws unconstitutional. That case was known as Lawrence versus Texas, and the ruling gave protection to intimate sexual contact, invalidating all sodomy statutes across the country. South Carolina, Mississippi, and Idaho, the only states to still enforce such laws. So, without giving too much away, here's what happened. John Doe, before he moved to Idaho and prior to 2003, was convicted of oral copulation with his wife. I know, which is the same reaction I had when I spoke to one of John Doe's attorneys this morning. Okay.
That was a crime in many states prior to 2003, and it continues to be a crime in Idaho. And it continues to be a crime for which, even if you were convicted before Lawrence versus Texas, you are required to register as a sex offender in Idaho for the rest of your life.
So basically, where he lived before, he did not have to register as a sex offender, but he moved to Idaho, he had to register as a sex offender, and we all kind of know the stigma that goes along with that.
Of course, that's exactly right.
And so that's what you're fighting against. That's what you want to see changed.
So we want to see two things changed. We want to see that change. We want to see that the registration requirement for this crime gets knocked down. But we're also asking the federal court to knock down the entire statute. In 2003, in Lawrence versus Texas, the Supreme Court said that these laws violate the Constitution. There's only a few states that continue to try to enforce these laws.
What do you think about Idaho being only one of 3 states that has a law like this on the books?
So, I think sometimes there's just not a legislative will to do the right thing. And sometimes that's what you have to depend on the courts to do, to come in and say, okay, the legislature is not following the Constitution. Somebody needs to force their hand.
So the Supreme Court ruled on this in 2003. I mean, that's 17 years ago. It's taken a long time.
I know. I had a case. I said there's 3 states that still do this. It's Idaho, Mississippi, and South Carolina. I had a case in Mississippi where we've been litigating the same thing since 2015 or something like that. And we thought that was outrageous in a long time. And now we're even 5 years further along, and we're still in the same place.
The crime against nature statute, by the way, was the same law used to prosecute the boys of Boise, a homosexuality scandal that tore through the city in 1955. Strugar says they aren't trying to remove the animal clause of the crimes against nature law or even limit the ability to prosecute crimes against minors or forcible acts. Idaho's Attorney General Lawrence Wasden and the Idaho State Police are named as defendants in this case, and as usual, the AG office won't comment on pending cases.